adjournment for item 7 on behalf of respondent 5, Lordship.
Respondent, who's for the petitioner? You have
He has
take
been
consent
informed by them, Lordship,
by whom?
by
You
Mr.
have been
Nair's
informed?
chamber. Yes, that this is what I have been told.
No, please inform.
They-
We'll accommodate you, but
Yes.
inform them.
Lordship, I am for the, in this matter, I am for the respondent number 4. I am also informed the petitioner.
You have informed, okay.
Yes, Your Honor. I am
All right,
informed the
matter
their
stands
personal-
adjourned at the request of MS.A. Verma and MS, what is your name?
P. Sharma.
P. Sharma, for the respondents. Matter be listed after 2 weeks.
Lordship, I have another prayer, Lordship. Item numbers 10 and 11. I'm praying for adjournment of 4 weeks, Lordship. I have the consent of both the parties.
Item 10 and 11, matter stands adjourned for 4 weeks.
Much obliged, Lordship.
The request of MS.A. Verma with the consent of the council for the petitioners. Yes.
Also, I have similar prayer for item number 23. For 4 weeks, matter may be adjourned. I have instruction to engage in senior counsel in the matter.
23,
Probal Sharma.
the request of Mr. M.H. Loskar matter stands adjourned for 4 weeks to complete his
I
instructions.
have prayer for listing of a matter tomorrow, your lordship. There are some defect I have flagged.
Next week. Give a date next week. Court master will give you a date.
May I have a lordship indulgence to mention item number 6, your lordship. Your
Six.
lordship, I am in a part heard matter today before Justice M.K. Kalita, your lordship. I want some accommodation. Would your lordship fix it sometimes in January 11th or 18th of January?
Oh, why? How do we know January 11? What would be the
11th?
position? We'll adjourn it for 4 weeks. You make a mention and
So
fix
your
a date.
lordship, if fix it for second week of January, that will be better.
No, you can make a mention.
Otherwise, it will all go off the list. That's the problem.
No, you can make a mention and fix it. That's what I'm saying. We'll adjourn it for 4 weeks.
Would your lordship make it second week of January? That will
We
be-
have not even given dates for December.
Oh.
So January, we can give you a date in December if you want. First week, second week of December.
December, I want to come.
So we'll adjourn it for 4 weeks at your request. After 4 weeks, you make a mention and see if you can get a date in January.
I
Matter
have to get a consent of other
at
side.
the request of Mr. P. Chaudhary, with the consent of the council for other side, matter stands adjourned for 4 weeks. Yes.
Thank you.
May please, your lordship, listed for motion tomorrow, a very urgent matter.
What is the urgency?
Urgent, there for promotion, regarding promotion.
Oh, promotion is no
No,
urgent.
no, promotion there.
We'll give you retrospective promotion if required.
Better. No,
Let it be
better.
next week. Next week,
No, your lordship make only tomorrow.
not tomorrow. Don't insist. If it is urgent, yes, tomorrow.
No,
This is
yeah.
not urgency. Promotion is not urgency.
The urgency in this.
Urgency would be if you are terminated from service,
No, my lord.
even transfer will understand. Promotion,
No, but matter is under process. So,
so it is not urgent.
No.
Let it be on 15th,
on
15,
Monday,
15 November.
not on Monday.
Monday you have to come alone.
Monday holiday.
Monday you have to come alone. I can't. So we can have it on 15th, earliest motion day. 15th, Wednesday.
Wednesday.
15.
Malat, with the consent of the petitioner's counsel, I beg to mention item number 18, Malat. I have some difficulty today, Malat. Can it be on the next Tuesday or Thursday, Malat? Any?
We can't fix a date once it
Ma-
gets adjourned.
ma-
Adjourned, the request of Mr. K.K. Parasar met for 2 weeks,
1 week, man.
1 week. All right. Consent for counsel for the petitioner has also been obtained.
Problem.
Yes.
Please, Your Lordship. Now, it's regarding my lord compassionate allowance, my lord. Pleadings are already exchanged, my lord. Your Lordship, I fix any day after 2 weeks, my lord.
Which
For-
matter?
This is not in the list, my lord. For, my lord.
You want it listed
Yes,
for admission?
admission.
Give it.
The problem.
29th November, yes.
Okay.
Lordship, similar prayer for listing for admission, your lordship.
29th November.
Another for contempt petition, your lordship.
It will come together. Contempt, fresh contempt or
Pending, your lordship.
pending? It will come 29th.
Yeah, please, Your Lordship, I beg to mention for listing of the petition for admission.
Admission. Give a date, please.
Sir, I was praying for an unlisted matter today. Yesterday, a notice was given to me, day before yesterday, a notice was given to the petitioner to appear in an inquiry proceedings today. Now that inquiry proceeding is barred by the Supreme Court, madam, by the judgment of the Supreme Court, it is a barred proceeding. Therefore, my lord, it will be taken up by the video.
Tomorrow,
Today she has to appear. My lord.
huh?
Today she is to appear in that inquiry, my lord.
She's
Day
aware
before
that there was an inquiry. Why was she?
My lord, no,
waiting
day
for so
before yesterday, the order for appearing today has come. Only 1 day difference was given. Day before yesterday, she approached the legal aid. They said it will take about a week. In the afternoon, she approached me. My lord, today I have filed the matter. I have got the file.
Today, unlisted, before rising of the court, if you can bring it.
I'll do my best.
Yes.
Sir.
Before
And
rising. Yes.
Yeah, please, your lordship. I am praying for listing of two writ petition, my lord. Next week, my lord. Any day.
For admission,
Admission.
the dates 28.
Public.
This is 24.
24.
You want to withdraw?
That's it.
Yes.
The consent has been given to withdraw the case.
Photocopy. Do you have a copy with you?
That's it. No, this is the
Photocopy. Mr. D. Monroe, learned counsel for the petitioner submits that the writ petitioner does not wish to press the writ petition any further. Accordingly, the same stands dismissed as not pressed. Interim order, if any, stands vacated. Anyone for the respondents?
Union of India.
Union of CGC appears for the unit. MSB Sharma appears for Union of India.
Public.
As per instruction of a client, my lord, I want to withdraw the petition.
Mr. B. Roman, learned counsel for the petitioner on instruction submits that petitioner does not wish press the writ petition any further. And he seeks to withdraw the writ petition. Therefore, writ petition stands dismissed on withdrawal. Interim order if any stands vacated. MSD Bora appears for the health department. Dismiss. Yes.
Here in this writ petition, your lordship, I could not appear on Tuesday. I had a personal difficulty. I was not well, your lordship. May I say the matter will be taken up with the writ petition on Tuesday, this coming Tuesday. If my learned friend has got no difficulty.
What is the interim order?
Interim order is stay of the disciplinary proceeding, because the issue as such was that it was already decided by a single bench of the Honorable Court as well as the division bench, wherein he was actually directed, given permission to basically join the NHAI on deputation basis. And even after that particular judgment, they have now issued a show cause notice on the same facts and situation, saying that you obtained, you set for the interview without obtaining any permission, which is actually hit by the principles of constructive res judicata in this, my humble submission. So may I pray the matter will be taken up on admission at on Tuesday itself, because even I am also suffering because this particular matter as such is hanging like a Damocles sword over my neck. So I just
You
want
withdraw the matter. Why are you suffering?
No, your lordship, because they had been actually pressurizing me to take up the matter.
Lordship, we have filed the IA for vacation of
Vacation
the interim order.
Huh? You want to file an objection? File it.
Already,
Pleadings are
Lordship,
complete.
affidavit has been
Everything
complete.
is complete.
Yes,
Complete in the IA.
IA
Writ petition also.
also writ petition.
Writ petition. Everything is complete.
Then either you press the IA for hearing the matter, we'll have to fix a date. We can't hear the matter just like that.
Yes,
Why
yes,
should we? Out of turn hearing.
yes, sir.
This is a question of vacating the interim application for vacation or modification. That's all.
Lordship.
Have you filed any objections here?
Yes, yes.
Yes, Lordship.
Everything is complete. Pleadings are complete. Just that my
Yes.
learned friend is actually insisting on a shorter date, that's why.
Yes, Lordship, it is since 2022. The
So
matter-
you argue your case.
Lordship,
Who's for the applicant?
Please for that.
I am from the
So
applicant,
please,
Lordship.
please submit. What is that?
Lordship. The petitioner's case is that he was serving in the BRO as executive engineer, Lordship. And the National Highway Authority on 21/20/20, Lordship, issued an advertisement for deputation of certain in the post of general manager. in the NHAI. In the post lordship, the petitioner has applied without permission and anything lordship. And thereafter, after application, he sought NOC from the lordship for permission to the authorities. His application was forwarded to the
What is the memorandum?
memorandum. Memorandum
29/9/2022. Where is that memorandum?
19.
Memorandum is state. Where is that memorandum?
Memorandum is at page already in the repetition. It is in page 85, lordship.
So why have you filed a vacating petition? Your petition has to be complete. Why are you seeking the vacation, modification, for what purpose?
Vacation lordship, they have said that on the basis of the letter dated 19/2/2020,
Hmm.
by which the authorities has rejected his lordship, his application for deputation. This honorable court has interfered with this letter 19/2/2020.
Huh.
And on this basis, lordship, now they are the authorities are initiating the disciplinary proceeding. But the fact is that the lordship, this disciplinary proceeding is completely separate to that of the 19/2/2020 letter. This 19/2/2020 letter is not recommended for lordship deputation. Now the memorandum of search has been issued to him on the ground that without any NOC and permission, he has applied for deputation as violating the rules, and also got selected for the deputation. And it is a misconduct.
Where is the 19/2?
19/2/2020, page 50, lordship of the petition.
Okay, please read.
Page 50, lordship. Application dated 6 February 2020 for deputation to the post of General Manager Technical in NHAI in respect of so-and-so Ramasta Kurala of Headquarters ADCPR is forwarded herewith along with disciplinary vigilance clearance certificate and other connected documents for your information and further necessary action, please. It is further submitted that officer due for high altitude area turnover and acute efficiency of officers eligible for higher altitude area posting. In view of the above, it is submitted that the case is not recommended in the organizational interest for information
So
and further
he was asking for deputation.
deputation.
That was rejected.
It was rejected.
This, he is posted, where is he posted?
Lordship, he was posted in lordship, PRO lordship in headquarters Yozak. Headquarters lordship. So it was when it was not recommended lordship, he approached this honorable court, and honorable court has interfered with this or lordship letter order, by not recommendation order lordship, it was interfered, and division bench also lordship upheld the order of this honorable single judge. Thereafter lordship, he was deputed to the NHAI, and after that lordship, the authorities have issued this memorandum of.
No. See, you have filed a stay vacating. This court has given an order staying this rejection.
That's it.
You want a vacation of this.
That's it.
So pursuant to staying this, he went on deputation.
Yes, lordship. He went on deputation, now repatriated lordship.
Now repatriate.
Yes, lordship, in May this year, lordship.
Now, how does it, why have you pressed for vacation of this now? This has become redundant now. This 19/2,
Lordship.
you are seeking vacation of which order?
Vacation of the lordship order by which interim order lordship by which the memorandum of search has been stayed.
Okay.
Memorandum of search is at
Oh,
page
29/9, sorry.
Yes, lordship.
29/9. Where is 29/9?
It is lordship at page 85 of the repetition. This is the memorandum of search, lordship.
85. $85.
85. Mary lordship.
Yes.
Ramasa Kural, Executive Engineer Civil, Headquarters CP Yozak, presently on deputation with NHAI, is hereby informed that it is proposed to take action against him under Rule 16 of CCA rules 1965. A statement of the imputation of misconduct or misbehavior on which action is proposed to be taken as mentioned above is enclosed. Ramasta Kural is hereby given an opportunity to make such representation as he may wish to make against the proposal. If Ramasta Kural fails to submit his representation within 10 days, receipt of memorandum, this is the Lordship memorandum, and the imputation of charge is at Lordship is at page 86. Page 86, Lordship.
Now,
But-
why this proceeding was stayed, Mr. Bora?
Yes, Lordship.
Your Lordship,
Why are you aggrieved by this? Naturally, you are aggrieved, but you have been given an opportunity to respond.
Your Lordship, the thing is, otherwise I would not have actually come before your Lordship paying this particular memorandum of charges. But if your Lordship peruses to the learned single judge judgment, which is at page number 70. It starts at page number 70, and the relevant portion is at page number 71. I'm sorry. Para number 70.
Yes.
I'd just like to read out, your Lordship, if I may, your Lordship. To examine the validity and
No, firstly, tell us who has filed the writ petition.
the petitioner Ram Ashtak Kural,
Same petitioner.
same petition,
Same petition.
Challenging what?
challenging this particular 19/2/2020
Rejection order.
rejection.
All right.
The basis for rejection was actually discussed at this particular paragraph.
So what was the finding of the court?
Finding was this particular rejection order was quashed on the ground that it was communicated to me on 9/6/2020.
Hmm.
And based on the Bachitra Singh judgment,
Hmm.
since I was not communicated on time, this particular letter dated 19/2 was quashed. Now, after this was quashed, and also in this particular, they have actually the basis that they have taken in this memorandum of charges. I'll read out the memorandum of charges also, the charge that I had not taken permission from the authorities to appear in the interview
Hmm.
for this particular post of General Manager Technical in NHA. And this particular issue was decided, thoroughly discussed. And the department was actually directed to produce records to say if whether or not he has accorded permission or not. The department could not produce any record, even though they were given ample opportunity to do something that you had accorded permission or not accorded permission, but they could not. Ultimately, what they did instead, they tried to push through the applications of certain other individuals who were not even selected in the selection process. And this honorable court, the honorable division bench, as well as the honorable single bench, particularly highlighted this fact that bias is actually meted out to the petitioner. And it is observed in the judgment also that they are
This was not appealed. No appeal.
not against the division bench judgment. It had attained finality. After it had attained finality, I was directed to proceed on deputation to the NHA. After I was issued the
No,
moment
after
order,
this single bench judgment.
Yes.
Was any appeal filed?
yes, the department filed an appeal.
That was rejected.
That was
Yes.
dismissed.
Yes.
And the honorable division bench judgment also,
Where is that?
the division bench judgment is at page number 76. The relevant page is at page number 79.
Lordship, the issue
I
in
may-
the earlier petition was different than
No, no,
this
Lordship.
issue, Lordship.
If I may complete, your Lordship,
Yes.
if I may complete.
Yes.
The settled position, the second paragraph, your Lordship,
Of
this page number 79.
79, yes.
The settled position in such matter is that the private respondent, the writ petitioner, was legally bound to take permission or NOC from his employer in case he was to sit in any interview for appointment on deputation in any other department or organization. In the present case, there was no specific denial by the employer when the private respondent or writ petitioner sought for such permission. Although the employer did not grant permission, at the same time, there is no specific denial for such permission or NOC. The order dated 19/2/2020 denying NOC to the petitioner was only communicated to the private respondent writ petitioner on 9/6/2020. That is after he appeared in the examination and was selected. there is nothing on record to show that the order dated 9/2/2020 was communicated to the private respondent or writ petitioner before 9/6/2020 or before he appeared in the examination. In fact, the finding of the learned single judge is that the order dated 9/2/2020 was never communicated to the private respondent or writ petitioner before 9/6/2020. When permission or NOC was sought, and when there was no specific denial by the employer, it was not unusual for the petitioner to assume that approval was deemed to have been given. This court is of the opinion that under the situation when there is nothing to show that there was specific denial of the NOC by the employer, but at the same time, when the same employer had approved the cases of 15 other engineers of the same department for deputation in the National Highways Authority of India, some of whom had not even cleared the examination, it only shows bias against the private respondent writ petitioner. When the borderless organization itself had recommended the cases of 15 engineers for deputation, no reasonable cause has been shown by the employer as to why NOC was denied to the private respondent writ petitioner. After this, Your Lordship, he was directed to proceed on deputation. He proceeded. They issued the movement order, and in the meantime, they then issued the impugn. They could not actually digest this fact that the petitioner somehow was successful in his writ application, and they issued this particular memorandum of charges. If I may take Your Lordship to page number 86, the memorandum of charges. Statement of imputation of misconduct. I don't know how, because they have already made up their mind. How? I'll show Your Lordship how. Paragraph number 3, I'll start from the beginning itself. The said Sri Ramaswamy Kural, while posted at headquarters DGPR East, had submitted an application dated 6 February 2020 for deputation for the post of General Manager Technical in National Highway Authority of India, and his application was further forwarded to headquarters DGPR along with connected documents dated 7 February 2020. The application of above officer was further forwarded to the Ministry of Defence by a note dated 19 February 2020.
So this disciplinary proceeding is with regard to the petitioner appearing in the interview without an
No.
NOC.
Yes.
Without NOC, yes,
Yes.
Lordship. And Lordship, earlier repetition is regarding 19/2/2020 recommendation, not rejection of
Right,
recommendation.
but
Both are separate, Lordship.
no, both are separate, but the direction of the single judge, which has been affirmed by the division bench.
It is already, he was allowed to go on deputation, Lordship. It was-
Exactly. So the NOC which you rejected, he was directed to be given to him by the court.
No, Lordship, NOC was, the honorable court has stated that since it was not communicated only after his selection to the post, it was communicated, Lordship. Therefore, this NOC, this order has no. is
Come to
not
page number
effective.
80,
Lo-
last paragraph.
Lordship.
Kindly read.
Last, we direct the authorities in the borderless organization to issue NOC to the private respondent.
Exactly. To
petitioner.
issue NOC. For what purpose? There's a direction of the court.
Lordship, it is the direction of the court to issue NOC, Lordship. But our case is that he, without any NOC and.
How is it relevant when the
Lordship,
court has directed you?
There is a guideline, Lordship, before.
No, your guidelines, you should have urged these guidelines before the court, assuming you have done it. It's rejected.
Lordship,
Assuming you have not done it. Constructive res
Lordship,
judicata.
he has approached this honorable court on the ground that he has applied for NOC, but before NOC, this order, he received this order of 19/2/2020. He has selected for the post for deputation, Lordship.
But that has been turned down by the court.
On the-
Court has said non-communication of the rejection is not a rejection.
It is on two ground, Lordship.
And
One is that,
subsequently, you have been directed to give an NOC.
yes,
So this NOC which you have been directed to give is not a separate NOC. It is the NOC which you preferred, which you rejected. And the
Lordship,
court directed you to give the NOC. So therefore, subject to correction, the NOC which he applied is the NOC which you have subsequently issued pursuant to orders of the court. So
Lordship,
now, how do you say that he proceeded to appear without NOC?
Lordship, this order dated 19/2 was interfered on the ground that it was not communicated in time. Lordship.
Exactly. So
It
what
was
is
not that it was-
what meaning do you subscribe to the directions.
It is not stated that it is illegal, Lordship. This order was illegal, therefore it is, Lordship, not effective. It is
The order doesn't say we direct the authority to issue a fresh NOC. Doesn't say so. It says to issue the NOC. Which NOC? NOC has to be applied for.
Lordship, he was since he was without NOC already selected.
But did he apply subsequently after the division bench?
No, Lordship, this honorable court's order, as per the honorable court also, he was allowed to go on deputation.
And you are not reading the order.
Lordship.
Read the order.
Lordship,
Page number 80, last paragraph.
Lordship.
BRO was directed to issue NOC.
Yes, Lord, NOC was issued and he was allowed to go on deputation.
Then, but as per your guidelines, as per your rules, are NOCs issued unilaterally or is it on the basis of an application?
Lordship, no, Lordship, this order was passed on the basis of 19-2 order. And this, Lordship,
19-2 order was issued on the basis of what?
he has applied after,
Exactly.
after he applied for a deputation, Lordship, he sought permission.
So this
And
is a
this
matter
one is
which will
not
require
executed.
consideration. This is a matter which will require consideration. You urge the matter at the final hearing.
And also, Lordship, this memorandum, it is still in the.
We are not foreclosing your arguments. We are only examining whether the interim order is required to be vacated at this stage.
This Lordship memorandum is issued on the ground of misconduct and misbehavior on the ground that in violation of the rules, Lordship, he has without NOC, without permission,
That will,
applied for deputation.
then we'll have to look into the matter will have to be heard. The matter will have to be heard whether the disciplinary proceedings initiated are a separate issue completely, divorce the directions of the court of both at the single bench and the coordinate bench.
Otherwise, also, Lordship, this order of the Honorable Single Judge has been dissented by the Honorable Delhi High Court, Lordship, on the ground.
The High Court is not binding.
No, yes, Lordship, but it is dissented that the authority, the court has no, Lordship, scope of judicial
Ordinarily
review
not.
in respect of.
Ordinarily
deputation.
not, but prima facie view is that you are proceeding against him for appearing without an NOC. Which NOC the single judge division bench has directed you to give, you have issued.
And it is, Lordship, already in a, this petition is premature, Lordship, because no action has been
May
taken.
not be, but
He
you
is-
have initiated. Why should you initiate? First, you have to satisfy that this appears to be a misconduct, prima facie.
Lordship, since there is a guideline, Lordship, may kindly see in our,
This would
I-
you'll have to address these issues before the court, which passed the.
kindly see our IA, Lordship, page 22.
We are not convinced that the interim order should be vacated at this stage.
Lordship, he may submit his objection, Lordship, and reply. And after that, if he is agree, then he can. come
Why
to
should
the-
anybody be subjected to a disciplinary proceeding? At all. Disciplinary proceedings are to be initiated when the department prima facie feels that there is misconduct,
Yes, Lordship.
allegation.
Lordship,
He has been given a notice, he has replied. You did not find his reply convincing. Therefore, now you are proceeding with the disciplinary proceeding. So prima facie, you are convinced that it is a misconduct. But you have to convince this court how it is a misconduct in view of two orders passed by the court.
because Lordship, only on the ground that this 19-2 order has been interfered by the learned single judge, they have approached this honorable court. But 19-2 order is separate to their piece of the Lordship memorandum of choice against the petitioner.
But that was not urged. Was it urged before the court that notwithstanding non-communication,
Lordship,
by virtue of these regulations, unless an NOC is issued, he cannot go and appear. That is your case.
Lordship.
Was it urged before the division bench? It was not urged. You ought to have urged these issues. You are now trying to re-argue the matter before the division bench and the single bench. That can't be done. Who appeared before the court? You are the counsel.
No, Lordship.
Then where is the other counsel?
Lordship, deputy SGI appear in the
Uh,
other.
See, you can't re-urge a new ground in by filing a separate writ petition now.
The petition is filed
But
on the
you are trying
same
to
ground,
urge this
Lordship.
ground. You are trying to urge this
Issue
ground.
is separate, Lordship.
Then you file a review. What stops you? You file a review, you file an application for a clarificatory order by the division bench that whether the authorities will have be given liberty to proceed. You file. You are urging a ground. The moot question is NOC was not issued.
No, it's not issued. It is rejected. Lordship.
No.
By
He applied.
19.2, it was rejected. NOC
He
was rejected.
applied. He waited. You 3-4 months later, you rejected it. Meanwhile, he attended the interview and was selected.
Lordship, what happened, Lordship? Immediately on receipt of his application, it was rejected on 19.2, but it was communicated on 9.6, Lordship,
Exactly.
by the officer against whom also this disciplinary proceeding is initiated. Because there may be some, Lordship, police against whom he
Law
also-
is mere issuance of an order, keeping it in the file will not be understood to be an order. It has to be communicated. It was not communicated.
And after that also, Lordship, the petitioner has not sought any clarification whether it is,
Yes, we have heard.
Lordship.
We have heard. Heard learned counsel for the parties. This IA has been filed by the Applicant Union of India seeking vacation, modification of the interim order dated.
And also, Lordship, in the departmental proceeding, Lordship, the scope of judicial review, there is some judgment, Lordship.
We are not hearing the entire writ petition.
Lordship.
We are hearing on whether it requires vacation. Vacating the interim order dated 18/11/2022. Mr. Boru, are you appearing in the matter?
I was waiting because in a petition I was made performer, but already this officer has again repeated it. He has come back to.
So you are still a performer here.
The performer, my rule is not there until now.
All right.
When yes, I is there, I just prayed for deleting my name in main petition.
All right.
Because my role is not there.
For vacating of the interim order dated 18/11/2022, whereby the following order was passed. Page number 21. The writ petitioner is an employee of the BRO. BRO.
BRO.
At the relevant point in time, he applied for a deputation for appearing. He applied for a deputation to go to proceed for being deputed as general manager.
General manager
Technical, NHAI. Stop. For which purposes he submitted an NOC before his competent superior authorities. Stop. The said NOC was rejected by the authorities by order dated 9/2.
19.2.
19/2.
2020.
2020. Stop. By the said communication, his request for deputation was not recommended on the grounds and reasons mentioned in that letter, in the communication. Stop. Meanwhile, however, this communication was ultimately communicated to the petitioner on
9/6/2020.
9/6/2020. 2020. Stop. This fact is not disputed by the parties. Stop. In the meantime, the petitioner, having not been communicated the rejection order of his NOC by order dated 19/2/2020, he appeared before the authorities of the NHAI and was selected for being deputed as selected for being absorbed as an general manager and NHAI on deputation.
On deputation.
Stop. Subsequently, when the petitioner received the communication order, he approached this court by filing WPC number
2804/2020.
2804 of 2020. This court, by judgment and order dated 19/7/2021, allowed the writ petition and directed the allowed the writ petition interfering with the rejection order dated 19/2/2020 issued by BRO. And further directed the BRO authorities to accord permission and issue NOC to the petitioner to appear in the interview, which is at the final stage for deputation in the NHAI, and not later than 15 days from the date of receipt of a certified copy of this order. Aggrieved, the BRO preferred an intra-court appeal, being writ appeal number 188 of 2021. Stop. A division bench of this court, by order dated 2/9/2021, dismissed the appeal and upheld the findings and confirmations, upheld the findings of the adjourned single bench, of the coordinate bench. Stop. While the division bench while dismissing the appeal, further directed the BRO authorities to issue the NOC within a period of 15 days from the date of receipt of a certified copy of the order. The relevant portion of the order is expected below page 79, tick to tick, 79, 80, 81. Stop. The petitioner thereafter was issued the NOC. He appeared in the interview, was selected, and he completed his period on deputation. You completed
Yes.
his period on deputation, and thereafter was repatriated to his parent department. Stop. The petitioner was then served with the memo. Where is that memo?
Page 85. 29 September 2020.
Memorandum dated 29 September 2022, whereby a statement of imputations of misconduct or misbehavior was issued, on which action was proposed to be taken, and the petitioner was given an opportunity to make a representation within 10 days. Stop. Pursuant to the representation made, the authorities not being convinced with his explanation,
No, Lordship,
proceeded.
in response to this memo, Lordship, he has not filed any reply.
No. We have filed it earlier.
Page 87, para 5, second line.
The initial inquiry was done, Lordship, here that he filed,
Why do you interrupt without listening to the order?
sorry, Lordship.
If you want to say something, wait for the court to
Yes.
pause and then you can say. Ki likh lo. Pursuant to his explanation submitted, the authorities, not being convinced, decided to initiate disciplinary proceeding against the court, against the petitioner. Where are the charges? Charges issued?
Last line, does the said Sri Ramasa Kural attended?
Page number.
Page number 87.
87.
Last line. Does the said Sri Ramasa Kural attended the interview for deputation without the explicit approval of the competent
Decided
authority?
to initiate disciplinary proceeding against the petitioner for attending the interview for deputation in the NHAI without the explicit approval of the competent authority, in violation of some regulation in violations of the applicable rules and regulation, and which amounts to misconduct on his part. Stop. It is at this stage, the writ petitioner has approached by way of filing the connected writ petition, which is WPC 7373 of 2022. Stop. This court, while issuing notice of motion on 18/11/2022, passed an interim order suspending the memorandum dated 29/9/2022 till the next returnable date. Stop. The said interim order has subsequently been extended, and is still pending and is still in force. Learned counsel for the applicant submits that this IA has been filed for vacation of the interim order in view of the fact that this is a disciplinary proceeding. The department is yet to form any opinion as to whether the misconduct has been committed or not. And the petitioner has not even filed his written statements. And in response to this memorandum, and therefore at this stage, the petition is in fact premature, and therefore the interim order ought not to have been passed. The application for vacating the interim order has been accordingly filed. The petitioner, learned counsel for the petitioner, further submits that in matters of departmental proceeding, the department is empowered to conduct any departmental proceeding against the petitioner, against any employees, including the petitioner. And the scope of judicial review of initiation of disciplinary proceedings is extremely limited in view of the judgments, in view of the law laid down by the apex court. The learned counsel for the opposite party writ petitioner has contested the application by filing necessary objections. Stop. The basic ground for objection of the application is that the NOC, which was rejected by the authorities by order dated 19/2/2020, was never communicated until 9/6/2020. Stop. The coordinate bench had held that this NOC is not an NOC in the eye of law and proceeded to interfere with the same. Stop. This order of the coordinate bench was upheld by the division bench in an appeal filed by the union, and the authorities were directed to issue the NOC within 15 days. Therefore, there is no question of misconduct by the petitioner, as the NOC was issued under orders of this court. So, having heard learned counsel for the parties, the short question involved in this entire proceeding is whether the petitioner, having appeared in an interview without the formal NOC, would amount to misconduct. Stop. From the pleadings, it is seen that the coordinate bench, by the judgment and order dated so-and-so, passed in WPC so-and-so, has interfered with the rejection of the NOC by a communication dated 19/2/2020, and has instead directed the respondents to proceed to issue the NOC, enabling the petitioner to appear in the interview. Stop. This direction was upheld by the division bench, and a further direction to issue the NOC within 15 days was issued. Stop. That being the position, prima facie appears that the NOC was issued on the basis of the application initially submitted by the petitioner. Stop. The rejection of the NOC by order dated 19/2/2020 having been interfered with, the issue of whether there would still be a misconduct without a formal NOC being issued, misconduct on the part of the petitioner to appear before the interview without a formal issuance of the NOC is a question which requires decision in terms of the writ petition. Stop. Under such circumstances, this court is not inclined to vacate the interim order passed on so and so date. The IA preferred is accordingly rejected. So having said that, considering the issues involved, this court is of the view that the matter would require urgent hearing in view of the disciplinary proceedings initiated against the petitioner and which are presently suspended under orders of this court. Stop. In the writ petition, you write, in view of the order passed today in the IA number so and so, matter be listed for admission hearing in the month of December.
That name is not.
That will be fixed by the registry.
Highly appreciated.
14 December. 14 December.
Problem.
Bank. Sweeper. Yes. What decisions have you taken?
Your Lordship, we have not taken decision. We have go by our the minutes, whereby that the appointment has been put under abeyance till the clarification.
Who's undertaking the cleaning services today? In the bank, in the branches, is it being done by the officers themselves? Or you have personnel to do it?
Is there arrangement?
That is the instructions you are supposed to
Your
place it
Lordship,
before
on
the
the
court.
last occasion that the sub-staff and the clerical staff
Yes, yes,
clarifications.
yes.
Your Lordship, there are 4 cadets. That is, we have mentioned in our affidavit at page number 99.
Page number
99.
99. Yes.
There are 4 cadets, Your Lordship. That is executive officer, clerk, and subordinate staff.
Page number 99.
Yes, sir. In my affidavit in opposition to the additional affidavit.
Yes.
The last paragraph, Your Lordship.
Yes.
That is, there are 4 cadets, Your Lordship. Executive officer, clerk, and subordinate staff. And the sweepers is very much well covered by the subordinate staff cadets, Your Lordship.
So,
And Your Lordship, that we have sent a letter to the Ministry DFS. And
so that we have heard that old story. What is new in that story?
yes, Your Lordship.
What is new in that story?
No, Your Lordship.
Nothing.
is-
Yes. Now, you mentioned that this notification does not apply to sub staff.
Yes. My lord, will see in the affidavit, additional affidavit that we have filed, we have stated that there is a policy of recruitment. Lordship may come to page 62.
Yes.
Now, this is the guidelines for recruitment of sweepers, full-time, part-time, on 3/4, half and 1/3 basis, and the mode of selection is interview. Lordship will see at page 67, eligibility criteria. The criteria there, 67 for eligibility criteria, Roman 2. There will be no stipulation for minimum educational qualification, but the candidate must not have passed class 10. Now, there is now if your lordship comes to their present policy of Indian Bank, his policy was of Aswell Allahabad Bank. Your lordship will find at page 80 for the post of, lordship will see at page 71, recruitment in sub-staff cadre. Now they have stated that after there are two categories, one security guard, 3.4, page 79, educational qualification is class 10, and the mode of selection is interview. And for other posts under sub-staff category, now there the bank will assess the vacancies for the post of housekeeper cum peon in the sub-staff category in the branch. Now this housekeeper cum peon, if your lordship comes to page 81 and see their job profile, that sweeping and doing those cleaning work is not part of the housekeeping and peon duty.
Where page number?
My lord, if your lordship comes to page 80 of the additional affidavit that we have filed, for other posts under sub-staff cadre vacancies, bank will assess the vacancies for the post of housekeeper cum peon in the sub-staff cadre in the branch offices including so. Then your lordship will skip to page 81. The eligibility criteria is plus 10 pass. At D, educational qualification, and the job profile at C. If your lordship goes to the job profile of this housekeeper cum peon, sweeping and cleaning is not part of the job. So, my lord, the sweepers do not come under the category of housekeeper and peon. And lordship will see there is a settlement which was arrived at page 87. This is the settlement arrived at between the management of Allahabad Bank and the Allahabad Bank Employees Coordination Committee. And at page 90, lordship will see %50 of the total.
So now what orders do you want?
Now, my lord, what I am trying to suggest of the bill, that this notification, first of all, this notification was issued when the interviews were already held. Secondly, my lord, this notification does not apply to the sweepers because the bank in their board meeting has accepted that. Lordship may have a look at their resolution of the board, which your lordship will find in their original affidavit, first affidavit at page 45. Now, proposal that agenda was proposal for amendment of recruitment policy, discontinuation of interviews in recruitment process for clerical and subordinate staff as detailed in the agenda. Approval is accorded for amending the selection criteria by discontinuing the interview process for recruitment in clerical cadre and subordinate cadre.
And what is the advisory of the finance department? Where is that?
That your lordship will find at page number 42. Advisory is to discontinue interviews in the recruitment process in public sector banks for junior level posts by the deadline of 31/12/2015. Clerical and sub-staff. Now, in the board's resolution, they have resolved or they have decided to discontinue interview in the recruitment process for clerical cadre and sub-staff, excluding the sweepers. And even today, even after so many years, they do not have a fixed policy of recruitment of the sweepers.
No, what the question of the court was, what is the status of any sweepers in the branches today?
Yes, they're on contract. They're getting the job done by way of contract service.
Yes, your
The requirement is there. Interviews were over and they have decided to keep in abeyance for an indefinite period.
lordship,
Now,
only the page number
Please let me
45.
finish. Now, my lordship will see that there is an agreement which says that 50% of the sweepers will be taken up to the position of housekeeper campion, which I have pointed it out by in that agreement at page 90 of the additional affidavit. 50% of the total vacancies of peon cum daftari identified by the head office in the respective area on 1st April will be filled up through change of designation from eligible part-time sweeper on half scale wages, part-time sweeper on 3/4 scale wages and full-time sweeper. And what is the mode of gradation? It is the length of service. Full-time sweeper putting 2 years of service will be upgraded. Part-time sweepers on 3/4 scale after putting 3 years of service will be upgraded, and upscale pay 4 years of service. So, my lord, the sweepers, they are taken to the position of daftari cum peon, which is a subordinate staff, which is again akin to this housekeeper cum peon if your lordship compares the job profile. So, in my respectful submission, the bank has not decided, not taken a decision. They have arbitrarily stopped that recruitment process for no apparent reason. This circular, even if it is taken into account, they have decided to discontinue interview in the recruitment process of clerk and sub-staff, excluding sweeper. And they are waiting for that because they are in a very happy position. They are getting the work done by the contract sweepers, and there are no other problem because they are happy. Now the question is, before our lordship, is whether this can be allowed to continue. And they have taken a stand.
Petitioners are they're also working.
Some of them are working.
Some of them are working.
That instruction I do not have, but some of them are working.
What about the other petitioners? Other writ petitions?
They are appearing, I do not know. Maybe of the same.
Against the same bank,
Yes, same bank, same recruitment process,
different
Maybe.
branches.
different branches.
What are the status of the petitioners?
Same, your lord.
Same means working, not working.
Not working.
Some of them are working.
Now,
Well,
they have
also-
taken a stand that the policy of Allahabad Bank will not apply in Indian Bank. Now, my lord, the question is, this initiation of the recruitment process was done by the Allahabad Bank. So the policy guidelines of the Allahabad Bank at that time will be relevant to take a decision as to whether the decision of erstwhile Allahabad Bank was in accordance with law or was it not arbitrary. Now, the
Also,
recruitment,
my-
they till today, they do not have any recruitment process of the sweepers. I mean, the process by which the sweepers will be selected. Or rather on record, this 2007 guidelines of Allahabad Bank says that it will be on the basis of interview. Now, even after this advisory, they have not come up with any process by which the sweepers will be selected. They have amended or they have decided to
See,
select,
your prayer for the direction to
declare the result.
declare the result
And whoever gets,
is of this, when were the interviews conducted?
my lord, prior to the issuance of that advice.
No, which date?
Yes, that I'm.
Your lordship, page number 61 of the additional affidavit is there.
I'm asking you the date.
Yes,
Yes, your lordship, that is the last interview was held on 21/11/2015.
yes, I have
And
given at,
your
it starts
lordship,
from page 58. I have given the date of interview of all the branches.
No, that's okay, but see, assuming we accept your prayer for issuance of a direction, results are declared, then what?
Then whoever gets will get the employment. Even if I qualify.
See, this is an advertisement of 2014.
Yes,
Interviews were conducted in 2015.
yes,
We are in 2023.
yes.
Can there be a direction to appoint
Now-
you
now, my lord,
for an
what-
advertisement of 2014?
Now, if your lordship finds that the decision to keep it in abeyance was illegal, arbitrary, then will your lordship not exercise the extraordinary power to?
We will
do justice?
exercise the power to issue a direction to decide on this issue by the bank,
My lord.
to
If,
take a decision with regard to the employability or employment of the petitioners as sweepers, considering their need in the branches. Also taking into consideration the fact that they are not included, the interview process, which was suspended. The selection process, which was suspended, was actually meant for sweepers. And the advisory is meant for sub-staff, excluding sweepers.
in that case, my lord, all the petitioners are not working. So some of them who are
See,
working.
the issue is, from 2014 onwards, there are change of events, change of people, change of so many things, age, employability, other factors. Now, if we issue a direction that in terms of this, you declare the results and make appointments,
Declare the results, and whoever, my prayer before a lordship is to take the recruitment process to its logical end. Now, in that process,
slightly late in a day.
my lord, the late in the
2023.
day because of their illegality.
No, your
And we were before your lordship at the appropriate time, and for some reasons, it was decided in a different way, ignoring many other things. And on review, we are before your lordship. Review was allowed. So the delay is not for
Where
any
is
other.
where is the review order?
My lord, the review order is there in the records.
Not in the pleadings.
My lord, this is not in the pleading because the review.
Some
order-
reference was made, I think. Give us a copy of the review order, let us see.
It is there, but hey, to side of- there is an order of the review order is there in the file, my lord. There's an order of review for 10/4/23.
Do you have a copy? Give us a copy. It was filed by the same petitioners.
Yes. Now, this writ petition was disposed of earlier, my lord. It was earlier disposed of on 3/6/2022, and then a review was filed, and that 3/6/2022 order was recalled. And the review was allowed on 10/4/2023. Paragraph 9 is relevant, my lord. Review was allowed and earlier order was recalled, and there was a direction for fresh consideration, the whole issue. The petitioners came before this honorable court right in time, my lord.
Your lordship, in the year of 2018,
Yes,
after 4 years of delay of 2014, your lordship, notification is of 2000.
You have no ground to object on delay
because it
when
is
you
your
have not
action.
taken a decision.
Yes, sir.
You
And
have to
still-
take a decision.
Your lordship,
The
my-
whole rigmarole before this court is because of indecisiveness by the bank.
Yes, your lordship, my embargo is only that I have referred the matter to the.
That's not
DFS.
an embargo. It's not an embargo. It's a lack of initiative of the bank to take a proper decision while exploiting the services of the petitioners.
Otherwise, your lordship, the ministry has
Is
already.
there any advisory to say that you will not frame regulations regarding appointment employability of sweepers? Do you have a regulation?
No.
Then?
Till today.
Do you require a permission of the Ministry of Finance? Do you require orders of the court?
And my lord, when the
Yes.
earlier, when it was disposed of this writ petition, the stand of the bank was that the interview was not complete. And in review, when we projected that, no, it is in respect of two branches where no applications were received within the cutoff date, the interview in all other branches were over. So then they have shifted the stand. Lordship may have a look at what was the earlier stand taken by the bank in their affidavit.
Yes.
Lordship may come to page 38 in the affidavit. Due to paragraph number 9, in reference to the statement made in para 6 of the writ petition, the defendant denies the statement as made herein and further state that due to instruction received from the Government of India, Ministry of Finance, Department of Financial Service, all the recruitment process of part-time, full-time sweepers were kept in abeyance till further instruction. Now, they have not disclosed the fact that by that time interviews were already over.
All right. You have heard the councils. We'll keep it for 14th for orders,
14th of this month.
November.
Can it be 15th, 14th? I have a 16th.
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 All right.
And Lordship, I'm relying on a judgment of 1993 SCC 157. Perhaps I've given one extra copy. Paragraph number 11 and 13.
You give a note, just give the citations.
1990, volume 3 SCC 157.
1990,
volume 3 SCC 157.
157.
And I'm relying on paragraph 11 and 13.
What is the
That
name of the
say-
party?
Party, my lord. N.T. Devin Kanti and others versus Karnataka Public Service Commission and others.
All right. Only one judgment?
Yes.
All right. Anything from the respondent?
Yes, your lord. Your lordship, 1985, 1 SCC 122, para 16.
Sorry,
1985,
1985,
1 SCC
1 SCC,
122,
122,
122, para
paragraph
16.
16.
Yes, your lord.
Name of the parties?
Name of the parties is your lordship, Jitendra Kumar versus the state of Punjab.
For what purpose?
That is, your lordship merely applying for the selection is not giving any right to publish the selection list, your lordship. And your lordship, in the same judgment as cited, that is N. Devin Kanti, para 11, your lordship.
Yes.
Your lordship, in 1990, 3 SCC 157 as cited by my learned senior friend, that is in that para 11, because there was in the advertisement, the rules was determined. But in this case, the rules was not determined. And we are only by the guidelines.
Okay.
Yes, sir. So para 11 may be referred to once, your lordship.
You want to refer to? Now?
No, your lord, not.
In the-
Maybe at the time.
But he is
Maybe
suggesting
see-
that paragraph
Para
11 is of-
11 is in his favor, not yours.
Not
Yes,
in
it
my
is
favor,
his
your
submission.
lordship. That is only to the extent that the rules was mentioned in the advertisement.
Yes, yes, okay. 16. Is this matter on 16?
for order.
For admission. We'll keep it for admission.
Hello, brother.
Yes, anything new?
Lordship.
Anything new?
Nothing as such, Lordship, but the only issue is regarding the presumption. The question was whether it will be a declaration by the civil court.
The consistent view of the court is, it
That
can be
the
presumed.
High Court has the authority to do so.
No, it's not a question of authority.
Or-
This is a query which had raised, requested you for little research and assistance if required. You see, if it is required to be proved,
Yes.
then why presumption? If it is presumption, where is the question of proof? Because it is not proved, it is a presumption.
I have seen the High Court.
Unless you have proof to the contrary.
Subscribe
If
to your
it can be
lordship's views,
proved
yes.
beyond all reasonable doubts or any doubt, then why go for a presumption? It is already proved. So that proof perhaps has to be understood in terms of materials to say that there is nothing on record to show that this person has been hard for the last 7 years.
7.
And you have nothing to counter that submission on record. That he had issued some letter or you have some picture.
As of now, there is
As
nothing.
of now,
There is nothing on
nothing.
record. That is-
Yes, Mr. Maheshwari.
Mayor, order has already been passed, my lord. Only he wanted a clear direction be issued, my lord. May I present your lordship, may I please to see order dated 19/6/23, my lord. Order has already been passed to pay the payment amount, my lord. But he wants that a declaration is needed. For that, he is not paying the amount, my lord.
19/6, where is that?
96 order, my lord.
Order, okay.
Yeah, my lord. 96/23, my lord. May I read the order, my lord? Heard Mr. So-and-so, pursuant to the order dated 5/6/23, the respondent corporation has filed an affidavit and gave details of the entitlement of the husband of the petitioner as well as pension under the employer pension scheme 1995. Accordingly, Mr. Sharma submits that the aforesaid amount can be transferred to the account of the petitioner if the detailed particulars are given. The Land Council for the petitioner submits that petitioner is also entitled for interest. Such claim for interest requires some determination. Accordingly, this matter after vacation, list this matter after vacation on so and so. Mr. Sharma, Learned Standing Council submits the decision to release the pension extra has been made only on the ground that the husband of the petitioner has been missing since more than 7 years, and therefore a presumption has been taken under section 108 of the Evidence Act.
Has
That is
to be
already
taken.
ordered.
So my submission was has to be taken. Presumption has to be taken because my entire endeavor was that an observation has to come from a competent court regarding this presumption. He is reading
I
into
have-
it. I understand that, but
I have already, my lord, given the particulars to the account, my lord.
All right. Heard learned counsels for the parties. This petition has been filed by the petitioner, whose husband was working as a mazdoor Is it a term Mazdoor or you have any other term?
Mazdoor, my.
Mazdoor.
Mazdoor.
Workman or Mazdoor.
Under the respondent Oil India Limited.
So, four different people.
Stop. The husband of the petition, late husband of the petitioner, was initially appointed on temporary basis for 12 months. Stop. After completion of the temporary service of 12 months, petitioner was confirmed as Mazdoor on 11/7/1985. Stop. The registration number allotted to the husband, late husband of the petitioner is 9/89/29. Stop. During the course of his service, while the petitioner was serving as assistant operator, within bracket, mechanical, he was subsequently promoted.
No,
Then the Mazdoor is assistant operator,
madam, maybe promoted, madam, I have to not have the.
subsequently working as assistant operator within bracket mechanical in the mechanical engineering section at Manabhum, 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 within bracket Arunachal Pradesh. The the husband, late husband of the petitioner, suffered a severe head injury on 3/8/2020. Sorry, 2003.
2003.
2003. Stop. Initially, the petitioner was given treatment in the Oil India hospital. Thereafter, he was shifted to a private hospital. And he had to undergo surgical procedure. Stop. He was discharged from the hospital on 31/8/2003. Stop. Because of the injuries suffered, the petitioner, because of the injuries sustained by the late husband of the petitioner, he suffered from what? Loss of memory.
My lord. Not a loss of memory, he some mentally problem is there.
Huh?
Mental sickness.
He suffered from some mental health ailment. Stop. Although the petitioner was treated in various hospitals, he did not fully recover from the ailment he suffered. Stop. Stop. Thereafter, on 9/4/2015, the petitioner was found missing from his residence. And since then, his whereabouts were not known by the family members, including the petitioner. Petitioner's husband. Stop. Salary of the husband of the petitioner was not released with effect from January 2006.
Because of his absenteeism.
Because of his absence. Stop. Subsequently, the family pension, gratuity, and other retirement benefits, which are payable to the petitioner or his payable to the late husband of the petitioner or the present petitioner in the absence of the husband of the petitioner, have not yet been released. Stop. The petitioner, being the legal heir and wife of late so-and-so, approached the authorities by filing several representations. Stop. Then what order was passed by the department?
No order was passed.
The representations did not evoke any response. Consequently, the petitioner has approached this court praying for appropriate redirection or order. Stop. Mr. A.K. Maheshwari, learned counsel for the petitioner, submits that under provisions of Rule 107-108
108.
108
Right.
of the Evidence Act, the petitioner was last seen by the family members on which date?
5-4, my lord.
5/4/2000.
5-4, my lord, but FIR was lodged on 9-4, my lord.
5/4
2015 law.
2015.
My lord.
5/4 2015. And since then, he was missing and his whereabouts have not been known. Stop. An FIR to that extent, FIR with this regard was also lodged by the
On 9-4.
by the petitioner on 9/4.
My
As such, in terms of section 107,
108.
108 of the Evidence Act, there is a presumption which has to be drawn that the person has been missing for the person who was missing for 7 years is to be presumed to be dead, and accordingly the family pension and other benefits payable to the petitioner ought to be released by the respondent authorities. So in support of his contentions, learned counsel for the petitioner has referred to and relied upon the following judgments. What are the judgments? You had relied on certain judgments.
My lord, I've given the list, my lord. I may shortly I will give another list.
We'll take it off. Following
My-
judgments. Huh? Per contra, Mr. A. Sharma, learned standing counsel, Oil India Limited, has submitted that the Oil India has contested the case by filing their counter affidavit. You had referred to a paragraph in the affidavit that they have accepted something in the affidavit, I recollect. No?
No.
No, in the affidavit, have they denied your stand?
No.
My paragraph 29, I have stated that I basically stated that there has to be some declaration. Paragraph 29 of our affidavit, running page 50. And since he was absent from 2005-2006, therefore,
Is there a death certificate enclosed?
No, my only my lord, police report.
Where is the police report?
My lord, first is my lord, last is my lord, final report is given at page my lord 75.
The respondent Oil India contested the case of the petitioner and submits that there has to be a declaration that the petitioner is presumed to be dead. No such declaration was furnished before the respondent authorities, and therefore there is no question of release of the pay or benefits as prayed for by the petitioner. Stop. Mr. Sharma, referring to section 108 of the Evidence Act, submits that under the provisions of the Act itself, the petitioner has to prove that the person has not been heard for 7 years. Stop. But in rejoinder, learned counsel for the petitioner submits that a police report has been received pursuant to the FIR filed, and the same is enclosed to the affidavit in reply filed by the petitioner.
Not my lord, additional affidavit.
Additional affidavit filed by the petitioner. Stop. As per the police report dated 4/1/2023, the late husband of the husband of the petitioner, one Babul Hazorika, aged about so and so, has been missing since 5/5/15, and during inquiry, the person could not be traced out. The authorities could not trace out the missing person. Stop. Where learned counsel for the parties have been heard. Pleadings have been carefully perused. Judgments cited have been carefully noted. Stop. The short case petitioner projected before this court is that the petitioner's husband has been missing since so and so date 2015. No? And as per the provisions of Section 108 Evidence Act, a person who has been missing from for 7 years will have to be presumed to be evidence. Have been that that the burden of proving a person who's alive and who has not been heard of for 7 years is on the person who makes such a claim. Stop. The Section 108 of the Evidence Act reads as under extract. Coordinate benches of this court in the judgments referred above have consistently held that where a person has not been heard of for 7 years, presumption can be drawn under Section 108 of the Evidence Act. Stop. The court in the earlier judgments, which are also found referred to in the judgments of the coordinate benches, have, while examining the provisions of Section 108 Evidence Act, had held that the provision, the presumption to be drawn under 108 is the death of the person after 7 years from the date it is shown that the person has been missing. When the person died and under what circumstances he died is a matter of fact, and again on which no presumption can be drawn. Stop. However, it is clear that once the persons who would have ordinarily heard from the person who's stated to be missing, namely the family members like the petitioner, and no contrary proof or evidence has been placed before the court or are in the custody of the respondents to show that the claim made by the petitioner is not based on facts, this court has no option but to accept the presumption that petitioner, having been missing for 7 years from so and so date, the benefit of Section 108 will have to be conferred. Stop. Accordingly, this writ petition.
My lord, may I pray the one thing, my lord? I have also prayed for interest, my lord. So, my lord, interest may be kept pending, my lord.
Interest for what?
For this amount. This amount was
Which
as
amount?
on 2006, my lord. Whatever amount they have want to pay, my lord.
But we are drawing the presumption today.
My lord. Presumption, but amount I am entitled to get on 2006, my
The
lord.
presumption of debt
Now this, why was the salary not released?
because of his absenteeism. He was unauthorizedly absent from 2006 onward.
Did you draw up any proceedings?
So causes were issued against him.
Then what
Only
happened to
notice.
that?
And thereafter, it is admitted by him that there was no work by him. So the principle of no work, no pay comes into picture. Lord.
No. He disappeared from a particular date.
From the company's perspective, 2005 was the date when he disappeared because of unauthorized absenteeism, and we
My lord,
issued
no,
no cause notice to him.
absolutely.
That your lordship will find at page 18,
My-
running page of our
But
affidavit.
you have to, there has to be a decision taken by the
Nothing was done, my lord.
company. You
Only
cannot
paper
simply
publication was
unilaterally
made.
decide. You will have to take a proceeding as per your provisions.
That is true.
Then,
So causes were issued against him.
No, my lord.
Thereafter,
so he did
Only
not
notice was
respond.
published.
lordship will come at page 58 of the running pages.
No, assuming it was issued, it was not responded, you have to have a decision on record that we issued ex parte, we
Fact
proceeded.
remains,
Uh,
he was absent. So he cannot take an undue advantage of that now. The fact remains that he was absent.
You permitted him to take. You did not draw up proceedings. You have proceeded.
Maybe a proceeding was not there. There was a lacuna on our part. But the fact
In
doesn't
that
say
view of the
this,
matter,
that he never worked.
the prayer of the petitioner for release of the pay and other benefits, the family pension,
Yeah.
family pension, gratuity,
Right.
and other retirement benefits, and the pay, no, retirement benefits be released forthwith to the petitioner. Stop.
I have given the account number, my lord. In that account, amount may be transferred, my lord.
Insofar as the salary is concerned, the petitioners, although the respondents had proceeded to on an inquiry, proceeded to initiate an inquiry, disciplinary proceeding against the petitioner, the same not having been culminated by taking a specific order, and the claim of the petitioner in respect to the salary will also have to be allowed, subject to the provisions of the rules and regulations followed by the company. Stop. All the amounts are directed to be released forthwith in the bank account number, which is
Page 83, my lord.
page 83.
My lord.
So in this regard, and I may be allowed to place some judgments. But the fact remains that he was not working. Maybe there was a lacuna on my part that I had not culminated my proceedings into a penalty order. But the fact remains that he was absent. And that he is not denying. The
In the
wife is
account
not denying
number,
that.
in the account details, which are furnished at the affidavit submitted by the petitioner at para 4, within bracket page 83 of the continuous paging, page 83 of the court records. You extract this account numbers when page 83. Stop.
Lordship will kindly record my objections in this regard regarding that area pay.
We have recorded your objections.
No, regarding the area pay, that maybe we had not culminated the proceedings into a penalty order. But the fact remains that he was absent and that has not been denied by the petitioner's hearing.
Of course, that is how we
So
have
that may be
assumed.
observed, Lordship. That may be brought on record.
But then you have not proceeded. There has to be something
I
on
am agreeing
record.
to that I had not proceeded. But the fact
Hmm.
still remains that he was absent. So the principle of no work, no pay comes into picture. Supreme Court judgments are there. I, on my part, may have failed, but that will not give you an undue advantage.
You submit the judgments, we'll have a look. We'll decide on
The Lordship
this.
will have it on some other day.
May I present
Not
my-
some other day. We are closing it enough of other days.
And I'll place at 2 p.m.
Not 2 p.m. You place it.
Because he is not denying to that aspect, Lordship, that her husband was not working out of 2006.
So we'll see
But
about it.
suddenly getting that benefit, it is an undue benefit for him.
My lord.
But the prayer is made for salary also.
I understand.
Then,
I understand.
then
But during the entire course of adjudication, he has admitted.
prayer for interest, which is made, is declined in view of the directions above. No interest.
How can you get an interest? 2022, the 7 years presumption will come in.
How you are saying you have withheld my amount 2006, my lord?
Why will
17
I
years
give it to
have
the
elapsed,
wife?
my lord.
Why will I give it to the
I'll
wife?
pass, my lord. I'll-
Your lordship, this is something going very. Why will I
I'm
give it
not
to the
saying
wife?
anything.
Why will I give it to the wife?
You
The
place your
presumption has
judgments,
come
we'll
now
have a
before
look.
this honorable court.
You place your judgments, we'll have a look.
I'll do that.
Dispose.
But he was not working. Her husband was not working. How can I pay for that period? It's public money after all, lordship.
Who stopped you from initiating proceedings?
No, we initiated.
Then what happened to that?
Maybe
These
it
are
was not
matters-
culminated.
These are matters of facts.
Maybe it was not culminated.
Then-
But then they are not denying the fact that he never worked.
So this maybe not culminated, could be that you are not inclined to reject this
But will
prayer
that
for
be
salary.
the advantage now of getting a salary
The,
of 40 that he had
rep-
never worked?
The representations were left pending.
Representations I have categorized in my affidavit. They were never received by us.
No.
Fair
Here,
enough.
admitted, my lord. Why he is making
enough.
false submission, my lord? That is
My
absolutely
affidavit,
incorrect.
I have categorically stated that the
No, no, no,
representations
no,
were
no.
never received
You
by
are
us.
admitted, my lord.
All right, we have now disposed if
My-
after disposal, where is the question about argument?
Otherwise, I had no qualms regarding this payment. In my additional affidavit also, I have
He has-
stated
He has
that we
kept
are ready.
pending since last.
We are ready to
month.
make the payments. We are ready to make the payments. In our additional affidavit, I have brought everything on record as to what amounts he is going to get. But
You
beyond
place your
2006,
you place your judgments.
but beyond 2006, that will be lots of
Yes.
Much appreciated.
Place your
period that he
judgments.
has never worked. Paragraph 23 of my affidavit categorically stated the representations dated such and such as claimed by the
You
petitioner were never
place the
received.
judgments if you have any.
I will place them.
Yes.
No word, no pay, doesn't get a look.
Yes.
The objection letter, that arbitrator. My learned friend wanted to less the clauses of the GCC.
Lordship, what I want to submit is that, Lordship, that this is an accepted matters, Lordship. Now, as per
Yes.
62(1) of standard general condition of contract comes under accepted matter. So here 62(1) clause 6, abandon of the contract, Lordship. So in that case, Lordship, the decision of the railway authority is final and it is not arbitrable, Lordship. As
Very well, we'll hear the matter then.
Lordship.
We'll have to hear the matter on this issue.
Where is the question of abandonment? We have issued for foreclosure. Well, if you will also see that page 68 of my petition. That cannot be said, where is they have said that we have abandoned.
68.
68, that is the matter. We have said that due to this force majeure clause, it may be, because Corona was there and the border dispute was there.
No, so that is what we have to hear, whether foreclosure or force majeure
No.
will be covered under abandonment.
Abandoned, my lord.
Hmm?
Where is question of abandonment? Where they have given the finding that we have abandoned the world? Your lordship may see, my lord. Next, page 70. There is no reference of my this letter. Where they have said abandonment? Now they have said that abandonment. Abandonment, where is the question of abandonment? It's the appointment of arbitrator only, my lord. Immediately it should have been, my lord. Page 70, your lordship, see, where they have said, we have abandoned work.
Arbitrator to decide which issues. What are the issues to be for arbitration?
Case 54 notice, my lord. That, my lord, your lordship said that page 1 to 1, my lord.
101.
They have not replied anything to this, my lord. Nowhere they have said that we have abandoned our work. One crore.
Pursuant to this, what reply was given?
Nothing, madam.
Nothing, Lordship, because Lordship 62(1), there is no provision for arbitrator, Lordship. The finding of the railway
No, but
authority.
why do you say this is abandonment? Have you issued any notice that
Lordship may kindly see 1/3/2000, page 60. 60, first we have, as the work is not in progress, Lordship, as per the agreement, Lordship, on 1/3/2021, we issued the 7 days notice to the contractor, Lordship, page 67 of the writ petition.
then?
Then, Lordship, here we have specifically mentioned in the last paragraph, as you have failed to abide by the instruction issued to you, so adequate progress of the work, you are hereby given 7 days notice in accordance with clause 62. So that is clause 62, what I have already shown, Lordship. Clause 62 for standard general condition of contract to commence work or to make good for progress, failing which further action as provided in clause 62 of standard general condition of contract, namely to terminate your contract and complete the balance work without your participation will be taken. So after 1/3/2021, on 9/3/21, next page, Lordship, he had submitted, then 69, page 69 may kindly see, Lordship. Here in the second last paragraph. Now, in order to avoid further financial loss for the balance work due to abnormal hike in the cost of construction material and labor cost by around 30%, which is estimated to be around ₹3 crores, in addition to the unanticipated financial loss already incurred due to the aforesaid hindrance, which is beyond our control, it is not feasible on our part to resume the work any further. Rather, better to foreclose the work. Under such above circumstances, we once again request your honor to consider our prayer for foreclosure of the work under clause 17 of GCC. Then, Lordship, we issued the 48 hours notice, 10/3/2021, next page 70, where also we have given him 48 hours notice, and subsequently after 48 hours notice, the termination order of 12/3/2021 was issued.
What is clause 63?
63 years, Lordship, page
Well, that is
page
page
50.
50. Page 50. Page 50. The first thing, we have to submit an application to the authority to decide the dispute. 120 days time is given. That also I will comply with 661.
Now, what is the response of the railway to that?
Nothing, my lord.
Then
How do
why
you
have you
say, my
not
lord?
decided?
I don't know. Then we have given 64. 63 also, we have waited for this. My lord.
Yes, Lordship, but next line is important, Lordship.
That your losses is.
Provided last few lines, Lordship. Clauses 8, 18, 22, 5, 39, 43A, 45A, 55, 55A, clause 5, 57, so and so 61A and 62(1) of standard general condition of contract or in any clause of the special condition of the contract shall be deemed as accepted matters. So this is 62. And in matters not arbitrable. So it is written, Lordship, 62(1) matters not arbitrable and decision of the railway authority thereon shall be final and binding as the contractor provided further that accepted matters shall stand specifically excluded.
So what is the decision of the railways?
Railway had terminated that contract, Lordship.
No, pursuant to 63(1),
Yes,
matters which are finally all disputes and differences shall be referred by the contractor to the GM.
Yes.
So the GM is supposed to notify the decision.
Lordship.
Has it been done?
One.
That is, our application is page 78, my lord, 63. The detailed application we have given. Repression.
But prior to that, they had that
No,
foreclosure notice is there. Lordship.
This is a contract matter, you see.
Yes.
63 categorically provides that in case of all disputes and disputes arising, differences and disputes arising out of the contract, you'll have to first refer it to the GM.
The GM.
The GM within 120 days.
Yes.
Will give a decision in writing. Where is that decision? That is
Prior to that, Lordship, they had in their letter dated 9/3/21, Lordship, this they had written to the GM on 3/3/22. And the foreclosure, they had requested for foreclosure in the year 9/3/21. So almost after 1 year, they had submitted this before the GM.
Whatever, 1 year, 2 year, if they have invoked that application.
Within 120 days, they have to, if they have anything, they have submitted on 3/3/22.
But then also you have to reply to something.
And one more clause, Lordship, there is page 54.
This page number 78 is a letter indicates it's an invocation of clause 63.
Yes. Within 13 days, we have submitted this.
So this clause 63 having been invoked, you are duty bound to give a reply. Where is the reply?
No, not.
So if you have not given a reply, obviously the arbitration matter will have to be referred to arbitration.
But that clauses are not arbitrable, Lordship.
But
In that case, Lordship, maximum that there may be a reply from the authorities in that
that is
case.
what we are asking you,
Clause.
whether there is a reply or not. Are you aware of have you completed your instructions, whether any reply is available, not available? Is the authority going to give a reply?
No, my instruction is that, Lordship, already we have financial loss on behalf of the delay by the petitioner, Lordship. And before the completion of the 7 days and 48 hours notice, they had foreclosure. So
No,
the
madam.
subsequently it was
Please
terminated.
understand something. You have read clause 63.1.
Yes, Lordship.
And the petitioner has invoked clause 63
Yes, Lordship.
at page 78. Your clause 63.1 at page 50 reflects that in case anyone files the contractor files an application under 63, you have to give a reply. Whether it is accepted, not accepted under these accepted matters or not is to be decided. If it is an accepted matter, then no arbitration. That is your case.
Yes.
But has it been decided by the railway authorities to that effect? It is a matter of interpretation. You are trying to interpret.
Lordship.
But there is no decision by the GM.
No.
So why no decision is taken?
Since they have not decided, that is why we have invoked 64, my lord.
So you take a decision.
Because page 54, Lordship, that is another clause that contractor shall not be entitled to ask for reference to arbitration before completion of the work assigned to him under this contract. So
No,
that is
that
also
will
there,
not
Lordship.
apply. That will not
Lordship.
apply. That will not apply.
So as per 64, my lord, 1, 2A, my lord, let them.
Now, if we have to accept your argument that having the railway authority is not decided 63.1
Yes.
and therefore 64 follows,
My lord,
then we'll have to decide whether it is an accepted matter or not.
this court will not decide, my lord.
Why?
This is the, my lord, this is also-
No. Kindly read 63.1.
Yes. Because it is the authority who has to, my lord, because
The-
there is no indication that we have abandoned the work.
No. See, it is the GM who has to decide the matters,
Yes.
notify the decisions
Correct.
in writing.
Yes.
Then, provided provisions under so and so of the so and so shall be deemed to be accepted matters. So in the first instance, it is the GM who has to decide whether this dispute which you have raised
Yes.
is covered under these sections to make it an accepted matter.
Correct.
And the decision of the railway authority shall be final and binding. So
Binding.
if it is an accepted matter, it is final and binding.
Yes.
And accepted matters are excluded from the purview of arbitration clause.
Yes.
So you are before this court saying that this is not an accepted matter.
Correct, my lord.
Therefore, you having referred this invoke clause 63,
64.
63 first.
First 63 we have,
So that having not been replied, you now demand for an arbitration.
my lord.
Now, before the court issues an order for appointment of an arbitrator, in
Right.
clause 63, it is the court who will have to now decide.
No, court need not decide, now. It is my lord, the authority who is to decide. And if anything is there, they can raise the point before the arbitrator. They can raise the point because Supreme Court has made it clear, my lord, if arbitration clause is there and the parties are there, the court has to appoint the arbitrator. Because this matter cannot be.
Now, in reference to arbitrator, who are the arbitrators to
My
be
lord,
appointed?
clause 60 points, last one, my lord. 64, 1, 2A. The demand for arbitration is decide a matter in question, so the dispute differences so and so, they have to refer it, my lord. 4 persons they will give. The differences, my lord. No, yes, my lord. Page 57, my lord. Page 57. 51. Page 51. In cases not covered under so and so arbitration, the consists of panel of 3 gazetted railway officers not below the administrative grade, or 2 railway gazetted officers not below the junior administrative grade, and a retired officer, railway officer retired not below the rank of senior administrative grade officer as arbitration. And for this purpose, railways will send a panel of 4 arbitrators of the gazetted railway officer, 1 more department, railway, which shall also include the name of the retired railway officer and panel to work, and the contractor shall within 60 days from the date written valid demand for arbitration received by the general manager. So they can follow, my lord. It is not that, my lord, your lordship can direct that as per the 64 3A2, let them appoint the arbitrator.
One more.
They will give, my lord, notice to us, my lord, 2 names of the arbitrator, 3 names will be given. We shall select 2 names.
One more issue is there, Lordship, although that was not taken because
Arbitration Act, DJ. Arbitration. Yes.
page 54, Lordship. Clause 9, Lordship. Sorry, clause 8. So here another clause,
Page
54.
54.
So another is that, Lordship, provision of, Lordship got it?
Yes.
Provision of clauses 63 and 64 to the GCC will be applicable only for settlement of claim or dispute between the parties for values less than or equal to 20% of the value of the contract, and when claim of dispute are of value more than 20% of the value of the contract, provision of 63 and 64 and other relevant clauses of GCC will not be applicable, and arbitration will not be a remedy for settlement of such disputes. So here, Lordship, value is also more, Lordship.
No, we are agreeable, my lord. We shall make only claim up to 20%.
That we have not taken because as per my instruction, it is an accepted matter. So in case of accepted matters, this clause will not come. But if it is not an accepted matters, then this is another condition, Lordship.
Now for this, who is to be appointed an arbitrator?
My lord, railway will give a name, my lord, to us. We shall select two names. From them, my lord, only one name will be appointed. Another will be appointed by the railway. Then the presiding arbiter will be appointed.
They
All are
have,
by railway.
have they furnished their names?
No, they have not. They, your lordship to direct, my lord, that as per 64(3), they have to furnish the name to us. We shall select. Actually, this is also in the Supreme Court, my lord, that whether they can do that. That is, as per the amended act, that also they cannot appoint, even general manager cannot appoint, but anyway, we are not opposing to that.
No, what is the amendment?
Yes,
Which was the amendment?
12(5), section 12(5). Notwithstanding any prior agreement or contrary, any person whose relationship with the parties or the council subject matter dispute falls under the category specified in 7C2 shall be ineligible to be appointed arbitrator. There is Supreme Court judgment now. The matter is before the Supreme Court whether the general manager can appoint. There two judgments of the Supreme Court are there. Some conflict is there. That is why it was referred to the Plaza Bank.
So under that circumstances.
No, we are not
orders can be
opposing to
passed.
that, madam. We are agreeable to that, madam. Let them.
No, you are agreeable to what?
Madam, to the procedure prescribed by them, because irrespective of the thing, madam. Those who are agreed by the same, madam, they can do it. We are not. Let them furnish the names.
What do you submit?
They can furnish the name.
Lordship, as Lordship, after going through it, what I found, Lordship, of course, Lordship, as per that 120 days, our stand is that, Lordship, as it is accepted matter, so no, perhaps no reply was given, Lordship. So let them approach the authorities or let the authority to give a reply to his decision letter that it is accepted matters at first to decide whether it is actually accepted matter or not. If it is accepted matter, then arbitration.
You have a time frame. You have not gone for the time frame. There's a 120
It
days.
is 2021, March 2021. I do not understand how my learned friend can say that we should approach that. After 120 days, we can always, my lord, issue the notice.
See, the problem here is if it is an accepted matter,
my lord, it is not accepted.
that is an arguable case.
No.
For you and for them, it has to be argued. Somebody has to decide, either this court
No.
or an arbitrator.
Arbitrator, it is, my lord.
No, so what will the arbitrator decide, whether it is accepted matter or not?
They can take the point there.
Assuming it is decided, it is an accepted matter,
Yes.
then there's no arbitration can be
No,
proceeded.
They have nothing to say. Let them take the point, my lord. Many cases, section 17 has.
So why refer it to arbitration to decide this issue? Either we direct the authority to
Yes,
decide or we decide it.
To decide, Lordship, or the authority.
We'll decide it.
No, that is not a question, my lord. Your lordship-
Why we can't decide it?
No, your lordship, my lord.
Let us decide the
No,
matter.
section 16 may be seen, my lord.
Hmm.
Section 16, 17, my lord, that is there, my lord. This is arbitral section 16, my lord, is a competence of the arbitral tribunal to rule on all jurisdictions. That is there, my lord. They can file a petition there. Section 16.
All right. So we have to decide your response first.
Lordship.
63, 64. 63, there is an application. You have not responded.
Yes.
In terms of the contract, why 64 should not be invoked?
In reply, Lordship, to sections, that is, his stand in paragraph 21, that reply was not given. My lords kindly taken page 119, continuation page. In reply to that, that is what is my statement, that Lordship.
119.
119, paragraph 24.
Yes.
Yes, 21 is his 20 paragraph 21 of the writ petition. My learned senior had stated about that their The deponent states as per general condition of contract or contract agreement, all dispute and differences of any kind whatsoever arising out of or in connection with the contract, whether during the progress of work or after its completion, and whether before or after the determination of the contract, shall be referred by the contractor to the GM, and GM shall within 120 days after receipt of the contractor representation make and notify decision
And
on all
foreclosure,
measures.
where is foreclosure? Under which clause? Is foreclosure a clause of the contract?
No, nothing, no decision has been taken.
No, no, why do you say under which clause of accepted matter does this dispute fall?
This, we have stated that abandon the contract. 62(1) or 62(1) clause 6. That yellow flag I have
62(1) clause 6 is not included.
abandoned the contract.
No, 62(1) clause 6 is not.
60-1 lordship, 60-1 whole is included. Later part lordship, second last paragraph. 60-1,
62(1).
yes lordship, 60-1, then Roman clause 6.
Where is 62(1)?
Lordship, I had that special condition of contract lordship. Yes, this
So-
is, yes, that green, yellow or green flag.
नहीं है, one है, two नहीं है.
Where is abandoning defined somewhere? Abandoning of contract?
Abandoning,
Is there a definition of what is an abandonment contract?
Nowhere they have said.
Now,
my lord.
assuming
Yes.
the authorities now decide on whether, in terms of 63.1, whether it is an accepted matter or not.
Well, that cannot be decided now, my lord. 120 days is over. 2 years over, my lord, 2.5 years gone. That is in 2021 we have demanded that. 25/3/21.
No, then you see, the difficulty is
Yes.
in view of clause 63.1, where
Lord, what my-
kindly listen to the court.
Yes.
In view of 63.1, there is an express bar of certain clauses which are to be treated as accepted matters.
Yes.
Which are outside the scope of arbitration.
Hmm.
You are now coming before this court under section 11.
Yes.
Invocation, appointment of an arbitrator. Now the question of whether the matter can be referred to arbitration or not. Is it to be left only to the arbitrator?
Look,
Is the court powerless to decide whether the matter can at all be referred?
Because Konkan Railway has been subsequently laid down, my lord, that no, court need not decide. Court is to only see, my lord, whether absolute clause is there or not. My lord,
You give
yes,
us the judgments, let us see.
No, I'm submitting, my lord, that where is the finding, my lord, that is abandoned the contract.
That is what we
Where
are
is there
saying.
a allegation that they have abandoned the contract? In the
That is,
affidavit also they have not
you
stated so,
show us the provision of foreclosure.
my lord.
Is there a provision for foreclosure?
No. Force major clause, my lord, that is clause 17. Clause 17. Force major clause.
If you want to rely on judgments, you rely, we'll take it up tomorrow, day after, whenever you want. Scope of
No,
the
no.
power of the court to appoint an arbitrator. You see, the difficulty is in view of 63, specific references to the clauses. Their case is that it is abandonment. You say this is not abandonment.
But
This
where
is-
is the finding, my lord, saying that before the court, my lord, without anything, my lord.
That's
is it-
right, that's right.
Whether my right under 63 is there or not.
No, Mr.
Ah.
Sewala,
Right.
please appreciate.
Ah.
There is no finding.
Ah.
Somebody has to give a finding. According to you, it is the arbitrator who will give the finding,
My
not the court.
The first thing, my lord, whether there is a allegation that I have abandoned the contract. There is allegation, any allegation is there? And that is why 63 is not barred, my lord. 63, we are, suppose it is.
So
not-
that finding has to be recorded by the court in view of the objection.
How many objection has been rejected?
Whatever they have raised certain objections. They raised certain objections. You see, subject to correction, subject to such
My lord, section
judgments that you may
16
refer to, that if-
Section 16 gives enough, my lord, power to the arbitrator, my lord, to decide his own jurisdiction.
quite right. So section 16, will you say override section 11? That section 11, there's no power of the court to even decide whether the matter can be referred to
I can-
arbitration.
In that case, my lord, it may come up next week, my lord,
It'll come up
Wednesday.
Wednesday. List on Wednesday for further hearing. It is submitted by the learned counsel for the petitioner that would like to rely on certain judgments to submit that the question of maintainability of arbitration is a power to be exercised by the arbitrator under section 16 and not by the court while issuing while exercising jurisdiction under section 11. MSB Sharma appears for the respondent. List on. When do you want it? 15th.
Yes, my lord, it may be, no?
15th.
Apply.
15th.
But may I take the
We are retaining it.
15 बंद है क्या? हाँ, Wednesday. Oh, done नहीं है क्या?
My pleasure, Lordship, my lord, in this matter, my lord, I have received a 5-page written instruction from. I want to, my lord, bring it on the record, my lord. Let me, my lord, allow me to sometime to file an additional. affidavit.
The problem is that already pleading has been completed. Affidavit, reply affidavit has been
No,
filed.
no, no, I have received the instructions, my lord,
And-
instruction.
And the thing is that petitioner will be retiring, will be on the verge of retirement in the month
February.
of January. February.
Yes, time is there.
You furnish the instructions, we'll take note of
With
it.
the furnished,
No, my lord, the 5-page instruction, my lord, which was not included in our earlier affidavit. That's why I want to bring it on the record, my lord. Within short period, but within a
because-
week, my lord.
our basic challenge is that they are denying the age of 65 years. Whatever reasons, my lord, that cannot be
What
supplemented.
are these
by your
instructions to
affidavit.
the effect of what? What instructions?
My lord, instruction is regarding educational institution, my lord. The criteria, other things are there, my lord. That was not included in the earlier affidavit, my lord. Only say this is not an educational institution. I can argue.
No, but do
right
you
now.
deny that he is a professor? He was
Professor
recruited
is
as a
there,
professor.
Professor is there.
Then-
Mere professor, he is not entitled for the 65 years.
Why
That
not?
is policy of the government, my lord.
What,
So,
where is the policy which excludes
Yeah,
professors not belong to be,
only educational institution. It is
no,
only.
no. That is not the interpretation. Where is that interpretation? Let us see.
My lord, we are
No,
also
my
not saying
lord.
that we are educational institution. We are a research institution. ma'am.
Research institution, my lord, is. not
Where is
included.
that decision of the cabinet?
Cabinet decision is at, my lord, page 78. It's a
Cabinet-
notification pursuant to the cabinet decision, my lord. Cabinet decision as such has not been there.
You bring the cabinet memorandum?
Just
Yes,
there
yes,
for the last
I
day,
have,
my lord.
I have.
Is it on record?
I think it was not annexed, my lord. That was,
You bring it on record, you give copies at least.
Yes, in additional affidavit, but I will bring all these things. Sir.
Decided to raise the age of retirement of all professors of educational institutions.
Educational institution.
So
that's what we are saying.
where else do you find professors?
No, no, my lord. This may be professor, assistant professor, associate professor, but this,
It is possible. That is why we are trying to go through
No,
the
this-
cabinet memorandum.
this is a memorandum
That
says.
educational institutions will only have professors. Where else will you find professors? In
No,
high
my lord.
schools?
No, my lord. It is only for research and how it is, my lord, constituted. It is funded by the my lord, state government and the ICSIR. 45%, 45%, and 10% is owned. And it is not fall under within the my lord, meaning of.
Is governed by the UGC.
That's why my lord, I want to bring you all these things, my lord. 1 week time, my lord.
All right, Mr. T.C. Chutia, Learned Counsel, for the government, additional senior government advocate, praise for is granted week's time to bring on record
A specific date may be picked. my lord.
Yes,
Not
the certain instructions which he says would be vital for taking a decision in the matter. Stop. Mr. T.K. Chakraborty submits the petitioner is going to retire shortly. Therefore, there's an urgency in the matter. Accordingly, matter be listed again. Uh, 2030 30.
Immediate. 30. No, my lord, before that, my lord, I can do it, my lord. 30 is another matter. Is there. 28 November.
28.
28.
All right, 28.
For further hearing. I'll complete it.
28.
Lordship has already heard the matter, my lord, for, can be taken up as part heard, my lord.
Okay, can be,
Otherwise-
my lord. I have no, my lord.
For further hearing, yes.
I'm obliged.
Deeply obliged, my lord.
Your Lordship, petitioner has challenged the court of inquiry. Is the case of the petitioner is that this is the second court of inquiry on the same set of facts. On the other hand, Lordship, our case is that this is the only court of inquiry and the previously whatever was there, it's only a kind of nature of preliminary inquiry, Lordship. Now a stay order is in his favor, Lordship. I have also
Uh,
raised a question on the point of jurisdiction also, Lordship.
We'll hear it.
Some urgency is that that is why this direction is there to dispose at the admission stage, Lordship.
Listed
He was-
on 5th of December.
Lordship, can it be in the month of November, or a little bit 21st or 23rd, Lordship?
All right, 21st November.
Lordship.
21st.
Their interim
Interim order will continue
obliged.
till the next date fixed. MSB Sharma for respondent CGC. List on 21st.
For admission, Lordship.
It's for admission.
And
28.
we wanted to have some authorities on the issue.
So we thought of disposing of the matter today, but
There is something.
may not be possible today. So we can keep it on Tuesday.
Tuesday, my lord.
Okay.
Tuesday.
Any date.
Tuesday. This matter again on Tuesday, 14th.
Yes, sir.
Lordship, any matter may be passed over for the time being.
Sir, kindly pass over the matter for today. I'm appearing on behalf of Mr. M.G. Singh. He is currently engaged in another matter in Impal bench through video conferencing.
The 2012 matter, anything survives? What is there in the matter?
My lordship, if possible, can you place it for tomorrow or any date?
All right, 15th. List on 15th.
15th.
Sorry, not 15th. 14th. 14th
14th.
November.
Yeah.
14 November is all right?
Okay.
Okay. List on 14 November. As it is submitted, arguing counsel, Mr. M.G. Singh is not available in station. Yes.
One is a similar matter, Lordship, your Lordship.
I had already heard the matter, only kept it deferred only because similar matter has been kept reserved by a lordship.
Then we'll post it for on 21st. 21st.
November.
We'll have it on 21st.
This month.
Yes, 21st.
Deep.
Matters be listed again on 21st. Yes.
May I please, your lordship? My lord, this writ petition is filed against statutory appeal, my lord. The first order was passed, it is at page 26, my lord. My lord, the allegation was the misconduct in duty, my lord. Misconduct and negligent in duty, my lord. And the order is very short, my lord. There is no any reason why I have been punished. The punishment was given that
Page number
26, my lord.
26.
Stoppage of one increment with cumulative effect, my lord. That punishment was given.
Where are the inquiry, where is the inquiry report?
Inquiry report was sought for, my lord, but that was not provided, my lord.
Yes, Mr. Goswami.
Lordship, this writ petition is pertaining to the order of appeal, or the disposal of the appeal, departmental appeal. That is annexure 9, page 35, Lordship. The departmental appeal was based on the report, which is views of the judicial department and the personnel department, Lordship. Page 35, Lordship. And Lordship, may I please to allow the call for the record, Lordship.
What records? Why? 35.
Yes, 35, page 35.
This is the appellate authority.
Yes, Lordship. This writ petition is pertaining to challenging the order of
Where is the
appellate
appeal
authority,
memo?
Lord, appeal memo is at page 27, my lord.
Yes.
Start from 28, my lord.
Yes. Where, your appeal memo?
My lord.
Where is it?
It is at page 27, start from 28, my lord.
28. But no proceeding was, no inquiry report furnished.
Lordship, that count, Lordship, the record of inquiry is necessary.
You find out. There's a categorical statement here.
The punishment also, Lordship, is simple punishment.
Whatever it may be.
Lordship.
Are you relying on any authorities in support of your argument?
My lord. My lord, kindly peruse at page 24, my lord. I filed an application seeking the inquiry report, my lord, but the
We have seen it. Your inquiry report has not been furnished.
My
But you did not take that ground specifically before the appellate authority. So under the circumstances, why are you challenging the order of the appellate authority? You are not challenging the disciplinary proceeding.
Yes, sir.
Yes,
My lord, the grounds are taken, my lord.
show us the ground.
It's at page 33, my lord.
We have seen it. Show us the ground that this was a specific ground taken. You argue you formulate your arguments and submit before the court. Why are you taking us through the facts? We can read it. What are your arguments?
My lord, I'm fine.
Why have you come before the court?
My lord, kindly peruse at page 33, my lord.
We have seen,
My
yes.
lord, I am working as a president of a organization of the driver Sangha, my
Why
lord.
are you harping on the facts? We are not concerned with the facts.
My lord.
Tell
And,
us what legal arguments are you formulating before the court?
My lord. In various time, we have raised our objection, my lord. Therefore, this show cause notice was initiated against me and held an inquiry, and this punishment was imposed, my lord. Thereafter, I have filed this appeal, my lord, and the ground was taken, my lord, that the contemplation of penalty in Rule 7 subclause 2 of the Assam Services Discipline and Appeal Rules 1964 is considered to be a minor in nature, and the wording are dear as to withhold increments of promotion, whereas in the case of appellant, it has been ordered to stop the annual increment, that too with cumulative effect, which is clearly not in consonance with the intent of legislature, my lord. Further, it is submitted that the penal provisions has to intercepted strictly, and the deviated would be illegal, and therefore awarding of penalty of stoppage of annual increment instead of withholding increment on promotion is wholly illegal, my lord. And thereafter, my lord, my lord, the appellant is found of guilty of misconduct. However, there are no reasons given for withhold the applicant guilty of misconduct in the fact of, my lord, it is said that the misconduct is found, but there is no reason, and it is not described in the order, my lord.
You have referred to the. Come to page 29.
It's 34, my lord.
29. Come to 29.
My lord.
Page number 29.
My lord.
Read para 2.
That White order dated 16/3/2015, the appellant was awarded a penalty of stoppage of 1 annual increment with cumulative effect under the provisions of Rule 7 subclause 2.
Where is that order? Where is that order? Is that order part of the proceedings?
16/3/2015. It is at page 26, my lord.
20?
26.
26.
My lord.
But this is the order of the, you said is the appellate order.
No, my lord, this is the order, the first time it was given, and the appellate order is at page 35.
This is the order of the disciplinary authority.
My lord. And thereafter the appellate order, it is at page 35.
You filed an appeal without praying for a copy of the order, proceedings, disciplinary order, findings of the disciplinary authority, inquiry officer. You did not apply.
I applied for the, I applied, my lord, but they denied to give. That letter is also there.
Where is there?
Lord, it is at page 24, my lord.
24.
The result was given in inviting a reference to your application on the subject cited above. I am directed to inform you that the certified copy of the statement given by you cannot be given to as separate for
No,
until
that
the-
is for the statements made
My-
by in the deposition, but inquiry report or until the inquiry report is submitted, has it been furnished to you? You don't know.
My lord, at page 25, my lord.
This is again for certified copy of the statements. Where is the inquiry report?
Not directly in the subject of the application, that word is not used, my lord.
Where is the appellate order? Where is the appellate order?
35.
35, my lord.
35.
35. The order is given that after the perusal of the order and careful consideration of the appeal against the order of the disciplinary authority, the undersigned is of the opinion that the decision taken by the disciplinary authority by the order dated so and so appears to be justified and proper. Therefore, having regard to the said decision of the disciplinary authority, the appellate authority is pleased to confirm the penalty.
Okay, heard. Learned counsel for the parties. You have not filed any response. Have you filed any reply?
Lordship, the ZAD will file the reply, Lordship. The name of the.
Heard. Learned counsel for the parties. This writ petition is
Yeah.
filed by the petitioner. For setting aside. Where is order 16/3/2015? 16/3 order.
16.3 is the order of disciplinary authority.
26,
first
page
order,
26.
and this 26, my.
And 17/2.
17 to page 35.
Approach this court praying for setting aside of the order dated 16/3/2015, whereby the petitioner was imposed a punishment of penalty of
2 increment. Stop 1 annual increment with commutative effect.
penalty of stoppage of
Stoppage
one
of
annual
one.
increment with cumulative effect on the provisions of Rule 7, Roman 2, Assam Services Discipline and Appeal Rules, 1964. Stop. The further prayer of the writ petitioner is for interference of the order dated 17/2/2017 passed by the appellate authority. In the appeal which is preferred by the petitioner, which was preferred by the petitioner against the order passed by the disciplinary authority. Stop. Learned counsel for the petitioner submits that petitioner is employed as what?
As driver, Lordship.
As a driver. Special attendant, pool driver under the Secretariat Administration within bracket establishment.
Vehicle
Vehicle
cell.
cell, Government of Assam. And was also the General Secretary of the Hodo Ahom Sarkari Gari Salok Aru Hohayok Sangha. Stop. During his service, the petitioner was served with a show cause notice dated 7th of January 2014, whereby the petitioner was asked to show cause on 3 charges, which are proposed to be, on which penalty was proposed to be imposed. Stop. As per the first charge, as per charge number 1, the petitioner was, it was alleged that the petitioner had forcefully taken signatures of few drivers by printing a reply in response to a government resolution taken on 13/11/2013. Stop. The RTI reply, the RTI application was alleged to have been submitted by the petitioner and by by obtaining forceful signatures of other drivers. By offering misleading suggestions. Stop. In terms of the second allegation, the second charge, the petitioner, it was alleged that the petitioner had submitted certain replies by forcefully taking the signatures of other drivers and by misleading them. Stop. The third charge against the petitioner is that in a consent letter dated 16/11/2013, the petitioner, instead of replying either in yes or no within quotes, challenge the resolution of the government decision, stating what the government is supposed to do, required to do, or not required to do. Stop. All these three charges were seen to be misconduct under the provisions of the Assam Civil Services Conduct Rules 1965. Therefore, proceeding was contemplated against the petitioner. Stop. In response to the said proceedings, the petitioner submitted the reply, and subsequently the disciplinary proceedings were initiated. Stop. The petitioner participated in the proceedings, and it culminated in the order dated. It culminated in an inquiry report which held that all the charges have been proved. It was held in the order. The findings of the inquiry officer were accepted by the disciplinary authority, and by the impugned order dated 16/3/2015, the penalty was imposed. Stop. Against the said impugned order issued by the disciplinary authority, an appeal was preferred, which was disposed of by the appellate authority dated 17/2/2017, rejecting the appeal filed by the appellate authority. Stop. Para. Mr. J.K. Goswami, learned counsel appearing for the department, submits that he would like to obtain instructions in the matter. Stop. It is seen, Para. It is seen that notices in the matter were issued as far back as 10/7/2017. Subsequently, on 17/7/2017, rule was issued. Stop. However, in spite of, no such counter affidavit has been filed by the department. Stop. Mr. Goswami, however, submitted that the records be directed to be called for. Learned counsels have been heard, pleadings on record have been perused. The impugned orders dated so and so and so and so have also been carefully perused. Stop. It is seen that the petitioner, during the course of the inquiry, filed applications for obtaining certified copies of the statements recorded by him, which, however, was denied by the inquiry officer, which, however, was denied by the competent authorities on the ground that These statements will be provided pursuant to conclusion of the inquiry report. Stop. From the pleadings, it is seen that from the pleadings, it is seen that there is no reference to any letter or communication by the government by which the inquiry report was furnished. Stop. The disciplinary authority accepting the inquiry report furnished by the petitioner while passing the impugned order dated 16/3/2015 does not record whether the inquiry report was furnished to the petitioner pursuant to the inquiry concluded. Stop. The appellate authority also did not examine the question of whether the inquiry report was furnished to the petitioner after conclusion of the inquiry. Stop. The respondent department, having not filed an affidavit in the matter, it is not the respondent, the government counsel is not posted with the required instructions as to whether the inquiry report was furnished to the petitioner or not. Stop. Better. The question of whether an inquiry report is to be furnished on a delinquent officer is no longer res integra, and the apex court in a catena of judgments and ratios have consistently held that the inquiry report must be furnished to the officer concerned or the government servant. Stop. Reference may be made to the judgment of MDECIL versus so-and-so, reported in so-and-so, and the subsequent judgments thereafter. Stop. Apex Court has categorically held that where the inquiry report has not been furnished to the authority, to the officer concerned, the subsequent proceedings will be held to be vitiated and will commence from the stage at which the inquiry report will commence from the stage after the furnishing of the inquiry report. Stop. That apart, in so-and-so versus so-and-so, the apex court had also examined and categorically laid down the powers of the appellate authority while deciding a statutory appeal. Stop. The appeal preferred by the petitioner and which was disposed of by the impugned order dated so-and-so is an appeal under the statute. Stop. The appellate authority therefore was duty bound to look into all the aspects of the matter, including the issues of whether there was any violation of natural justice during the course of prior to the issuance of the imposition of penalty. Stop. These aspects are not found to have been elaborately discussed in the order of the appellate authority. Stop. Having discussed the facts and circumstances in the matter as above, ordinarily, this matter ought to have been remanded back to the authorities to for issuance of a for service of furnishing of the inquiry report on the petitioner, and thereafter the proceedings will have commenced. Stop. However, neither the petitioner nor the respondents have placed before the court are any material and are unable to submit to a pointed query made by the court as to whether the inquiry report was furnished on the petition. Stop. In that view of the matter, this court is of the considered view that ends of justice will be met if the appellate order dated so and so passed by the appellate authority is interfered with, and the matter is remanded back to the appellate authority to examine all the issues and pass a detailed order on the appeal. Stop. While deciding the matter, the appellate authority will also take into consideration the various judgments of the apex court rendered in respect of the adherence to the principles of natural justice, and as has been held consistently. Stop. In terms of the above, the writ petition is disposed of and allowed, interfering with the impugned order of the appellate authority dated so and so. The matter now stands remanded to the appellate authority, namely so and so, and the appellate authority will decide the matter within a period of
2 months.
45 days, 60 days
60 days.
from the date of receipt of a certified copy of this order. Stop. While deciding the matter, the appellate authority will also take into consideration the facts and circumstances as to whether the inquiry report was at all furnished on the petitioner as per the records available in the department. And if not, then consequential orders are required to be passed as consequential orders as deemed proper may be passed by the authorities concerned, keeping in view the law laid down by the apex court in MD CIL versus so and so. Writ petition.
Put the facts very briefly, my lord. The petitioner is serving as an upper division assistant in the Khadi Commutative Court. She was suspended on the 1st of August 2023, and a disciplinary proceeding was initiated against her by charge sheet dated 3/8/2023. This culminated in an inquiry report, and the inquiry report was challenged before this honorable court. Lordship may kindly have page 52, the earlier order passed by the inquiry by this honorable court on the inquiry report.
Page
52, my lord, is the order. It starts at page 50. Lordship would like to have page 52.
Yes.
Para 4. Shri so-and-so learned counsel of the petitioner submitted that the procedure laid down in law for conducting disciplinary proceeding has been grossly violated in the instant case, and the department has failed in its basic responsibility to prove the charges through witnesses, in which case the petitioner would also be required to afford an opportunity of cross-examination. Then Lordship would like to come to page para 5. Per contrast, Shri so-and-so learned standing counsel has submitted that the allegations are serious, which relates to submission of fake documents and to secure employment. He further submits that the statement of an official of so-and-so was produced in the inquiry, and as per the same, the allegations to established. Shri so-and-so learned standing counsel, however, does not dispute the fact that there were no witnesses in the inquiry, except for production of the statement of the official of the SEBA, and also the fact that the witness number 2 was made the presenting officer by the inquiry officer himself. Now, Lordship will see the inquiry officer had appointed a presenting officer during the inquiry proceedings. All said and done, at page 54. At page 54, my lord, 3 lines from the top.
Your grievance was that the inquiry officer has proceeded mala fide. Therefore, you arrayed him as a party.
My lord,
the court allowed the writ petition, remitted the matter for de novo inquiry.
My lord, only
Fresh
one
inquiry.
sentence. This court is of the opinion that the procedure adopted after issuance of the so-called notice dated 3/8/2003 is not recognized by law. Now, my lord, what they have done is on 30/10 they give me a notice to appear again before the same inquiry officer.
So, but where is the finding of the court that the same inquiry officer cannot be
My
appointed?
lord, leaving that aside, my lord, I'm not on that ground at the moment. Lordship will kindly have 30/10 and directly appear before the same inquiry officer. On 3/11, I request him, which is the date for my appearance, I request him that I'm unable to appear because I have not been paid my salary for July. I have not been paid my subsistence allowance from August onwards, and till date I have not been given any monetary help. I had to approach the honorable court with the litigation. I'm totally in penury right now. Please postpone the date till my subsistence allowance and other allowances are released. That Lordship would find at page 14. Now, my lord, by an order, This was also informed to the disciplinary authority. Now, the disciplinary authority's order, Lordship, will find at page 71.
What is your prayer today?
Well, my prayer today is that till the time that they release my substance allowance, they should not proceed with
How is it difficult to,
My lord, I will just,
where are you posted?
my lord, I am posted at Guwahati.
Then where is the proceeding held?
At Guwahati.
Then
Well, I stay on the outskirts of Guwahati.
whatever it may be, whatever it may be,
My lord, the Supreme Court says, without subsistence allowance being provided, the participation.
when were you suspended?
My lord, 1st of August 2023. I have not been paid my regular salary for July 2023 also. Lordship, will kindly have this.
Who's for the respondents?
My lord, we had informed him, it is the Khadi Gramodyog Board, whoever standing council, we have served copies on their office because he was not available today.
When is the next date for the inquiry?
My lord, today at 11 o'clock, I was required to appear, my lord. Therefore, I had made a mention in the morning. Lordship allows me
What
to.
is the next date fixed?
My lord, 11 o'clock, I have not been told. Today is the date I am required to appear at 11 o'clock, that Lordship will find.
Then we'll take it up, tomorrow. You give him a copy.
My lord, the copy has been served on the department.
Mr. Goswami?
Manir is there.
Huh?
Standing council, Mr. Manir is there.
Oh, whoever is there.
Manir is there.
This board is under which department?
It is Khadi board. Khadi board, it is under. Yes, sure. It is
Which department?
Khadi Gramodyog Board, my lord. It's a board. my
Assam
lord.
Khadi and Village Department.
So you are a government council,
Lots-
you get your instructions.
Lots.
What steps
I'll
have
furnish
been
the copy,
taken?
lots.
Why no subsistence allowance has been
Lots.
paid?
Lots.
And my
We'll
lord,
take it up tomorrow.
Lots.
my lord, today, if any adverse orders has already been passed.
We'll take note of that. You don't know what adverse orders have been passed.
My lord,
You don't even know what orders were passed. So in vacuum, how do we pass an order?
Today since they.
Your prayer is for stay of the proceedings.
My lord, yes.
Today, there is a date.
My lord.
Some order may have been passed. It may be that the matter has been deferred without passing any order. Possible. So you get your instructions from your client, we'll take it up tomorrow. And you serve an extra copy or whatever is
Lordship,
necessary.
Right now, my lord.
Serve him a copy, Mr. Goswami, please get your
Lordship,
instructions.
I will.
You see, subsistence allowance is a
Lordship.
It is not a bounty.
mandatory requirement. It's not a bounty. You can't,
Lordship. I will.
In fact, Supreme Court.
you have to make a payment.
Supreme Courts have, so the Supreme Court, Honorable Supreme Court has set aside that part of the inquiry which was conducted prior to payment of substance allowance.
You
Entire inquiry was-
point it out tomorrow. The matter be listed tomorrow as it is submitted by the Learned Council. That copies have been, as the Learned Standing Council Khadi Board is not available in court. In spite of advance copy being served on the council as stated by,
Not by the, another councilman, on the board I have, because he was not available. I took the,
in spite of advance notice being served on the board. Stop. In his absence, the court has requested Mr. J.K. Goswami, Learned Additional City Government Advocate, to address the court by obtaining the instructions from the parent department, through the parent department, from the Khadi board if required, as to whether subsistence allowance have been paid to the petitioner, and if not, the reasons therefore. Stop. That apart, the Khadi board will also place before the court if any orders have been passed today, as it is submitted by the Learned Council for the petitioner, that today is a date fixed. Sorry, not by the Khadi board, with the inquiry officer. In the inquiry proceedings, as today was one of the dates fixed by the inquiry officer. Considering the urgency expressed, matter be listed tomorrow again. Interim orders to be, well, we need not mention it. We'll consider it tomorrow.
is that date?
Yes.
I'm obliged.
Tomorrow. We'll have to take it on some other date.
Some urgent matter, 2-3 times have been.
Whatever it may be, but we have to rise at 2:15.
I understand. Maybe it should 21st or 23rd November.
23rd, even date doesn't.
21st or 23rd. Hearing date.
21st. 21st November.
Similarly, 19 also, my lord.
Huh?
19 also.
No, not like that, not like that. What urgency is in there on 19?
19. Item 19.
Item 19 or whatever.
I will pick up 23rd. Maybe pick up 30th of December, 4th December.
4th, 5th December.
Fifth.
Yes.
Obliged, Lord.
Other matters deferred.
Lordship, item 17 can be held on 5th of December, Lordship.
Item 17 at the request of learned councils. You are appearing? 5th of December. Be taken up on 5th of December.
Obliged.
Yes.
Item, my lord, item 20, my lord. Any date may be given.
20.
20. Regarding termination, my lord.
Yes.
So any date may be given.
5th of December.
Item 21 also, any date can be given. Item 20.
What is the matter?
Regarding promotion, your lordship.
Oh, promotion will be 14 December.
Obliged.
Okay. Item 22, I have given it. Yes.